the critical issue here. We accept that the MOU says that neither state would object to the other's submission to the CLCS. That's not in dispute. The critical issue here is whether the MOU, beyond its no objection language, obligates the parties to a specific means of resolving their maritime boundary dispute. On this issue, Kenya's conduct in 2013 and 2014 is telling. At no time during that period, when bilateral negotiations on the maritime boundary were being proposed and conducted, did Kenya ever suggest that the MOU established a method, let alone an exclusive method, for resolution of the boundary dispute. To the contrary, Kenya's sole contention about the MOU was that it was a non-objection agreement with which Somalia had to comply. That was Kenya's only stated purpose in putting the MOU on the agenda for the bilateral meetings. Kenya seems to have only belatedly discovered, after this lawsuit was commenced, that the MOU bars any resolution of the maritime boundary dispute except by negotiations following action by the CLCS. Kenya admits that it never previously expressed this interpretation of the MOU. Professor Forto attempted to excuse this failure on the ground that Kenya had no prior occasion to make its view of the MOU known. We disagree. If this were truly Kenya's pre-litigation understanding of the MOU, it's reasonable to assume they would have brought it up in 2014, at which time, under Kenya's current view, the MOU would have prevented the parties from conducting any negotiations for the purpose of resolving the boundary dispute because there had been no action by the CLCS. The March 2014 negotiations were followed by a second round of talks 4 months later. Ambassador Muchiri told you, quote, "It is clear that Kenya initiated the meeting to discuss the MOU." That, too, is at odds with the record. Tab 15 and on your screens is a note verbal sent from Kenya to Somalia, inviting it to a second round of negotiations in Nairobi in July 2014. You will see that Kenya's invitation explicitly refers to, quote, "the negotiations between the government of the Republic of Kenya and the Federal Republic of Somalia on the delimitation of our overlapping maritime boundary." In the following paragraph, the note invites Somalia to the talks expressly to, quote, "discuss the issue on the delimitation of the two countries' overlapping maritime boundary." No reference is made to any discussion of the MOU or even to Somalia's objection to Kenya's submission to the CLCS. At tab 16 is the joint report of that July 2014 meeting. You were told yesterday that, quote, "maritime delimitation was discussed only in the most preliminary way." That is not what the report says. It establishes that the purpose of the meeting was reflected in its title, quote, "the Kenya-Somalia Maritime Boundary Meeting." The negotiating teams both made presentations on the issue of the maritime boundary, and, quote, "intense discussions between the two sides occurred in the presence of the two foreign ministers." Kenya now attempts to recharacterize this negotiating session. Its effort is defeated not only by the joint report, but also by its own internal report on the meeting, dated 8 August 2014. Somalia did not have this report at the time it filed its written statement in response to Kenya's preliminary objections, because Kenya chose not to disclose it when it filed those objections last year. The Kenyan report was only obtained by Somalia in June of this year with the assistance of the court after Somalia requested that Kenya produce all internal records pertaining to the negotiations that took place in March and July 2014. You can see this internal Kenyan document at tab 17. It's addressed to the Foreign Minister of Kenya and reports on, quote, the second boundary meeting, which it describes as a, quote, continuation of the March meeting. It does not mention the MOU at all. This is a significant omission in a Kenyan document intended to memorialize the key points discussed at the meeting. Instead, the document reports exclusively and extensively on the parties' exchange of views with regard to their maritime boundary dispute. As this report makes clear, what occurred was far more than a mere expression of so-called preliminary views. As described on the second page, Kenya's presentation addressed, quote, applicable maritime laws in Kenya, factors considered in arriving at the parallel of latitude, and a conclusion presenting the scenario, parallel of latitude, after application of the said factors. The document also notes that Kenya referred to case law and cited state practice. Such a detailed presentation is hardly a preliminary view. According to the report, Somalia made an equally detailed substantive argument in favor of its position that the boundary should be based on equidistance, also making explicit reference to case law. Tab 18 is Somalia's internal report of the meeting, which is consistent with Kenya's in regard to the matters discussed, including the extensive and detailed presentations made by each side in respect of its views on delimitation of the maritime boundary. Somalia's internal report of the July 2014 meeting, as you heard yesterday, includes remarks made by Kenya's foreign minister that are not reflected in Kenya's internal report, as seen on page 2, to the effect that, quote, if no agreement could be reached between both countries might resort to international arbitration. Kenya has disavowed that statement, including by means of a declaration by the foreign minister dated 5 May 2016, 21 months after this case was commenced. Somalia stands by the accuracy of its own contemporaneous pre-litigation report. In particular, Somalia underscores the two sentences immediately preceding the one that Kenya disputes. The foreign minister notably does not dispute the accuracy of those two sentences in her late filed declaration prepared for purposes of these hearings. They are now on the screen. Quote, Minister Baile, that is Somalia's foreign minister, asked Minister Mohammed, Kenya's foreign minister, as to how long would both countries continue to have their delegations entangled in these heated discussions without any possible solution. Minister Mohammed of Kenya stated that although both delegations are far apart, she would like both teams to meet again and attempt one final time to find an amicable solution. One final time to find an amicable solution. As you heard from Somalia's agent, a third and final meeting was scheduled, but without explanation, the Kenyan delegation simply failed to show up. Nor did it respond to Somalia's urgent inquiries by email and by letter correspondence, asking Kenya when or whether the meeting would take place. At tab 19 and on your screens is a letter from Somalia's foreign minister to Kenya's, dated 26 August 2014. The letter reads on page 2, quote, "Further, as Your Excellency requested, at the conclusion of the meetings in regard to the pending dispute in Mogadishu on 25 and 26, I'm sorry, I lost my place. At the conclusion of the meeting on 29 July, the Somali delegation agreed to hold one more round of meetings in regard to the pending dispute in Mogadishu on 25 and 26 August. The Somali delegation is deeply disappointed that the Kenyan delegation did not arrive on the agreed dates, preventing the meetings from taking place." No response to this letter was received. Somalia's decision to come to this court following unsuccessful substantive negotiations, which left the parties far apart and without prospect of settlement, together with Kenya's unexplained no-show at what was agreed would be the final meeting, cannot justly be described as precipitous. Much less can it be described as deceptive. Mr. President, what you heard yesterday simply cannot be squared with the evidence, which, as you have seen, consists of contemporaneous documentation whose authenticity and reliability are unchallenged, and includes materials produced and signed by both parties. That evidence makes it unmistakably clear that Kenya saw no contradiction in 2013 and 2014, before this case was filed, in proposing and engaging in negotiations to resolve the maritime boundary dispute long before the CLCS could issue its recommendations. At the same time, it was invoking the MOU to get Somalia to withdraw its objection to Kenya's submission. That is because there was no contradiction in Kenya's position then. It considered the MOU to be a non-objection agreement in regard to the parties' submissions to the CLCS. No more and no less. Kenya knows this evidence puts them in a difficult, if not desperate, situation in their attempt to invoke the MOU to escape the court's jurisdiction. Desperate circumstances often breed desperate measures, or at least desperate arguments. And that is the likely explanation for the argument elaborated for the first time yesterday. Previously, in its preliminary objections, Kenya argued that under the MOU, the method of settlement of the boundary dispute was, quote, to negotiate a full and final agreement on the maritime boundary delimitation after CLCS review of their respective submissions. They changed that yesterday. Their new argument, fabricated to fit the uncomfortable facts, is that the MOU did not prevent the parties from negotiating a resolution of their maritime boundary dispute prior to CLCS action. It only prevented them from reaching an agreement. Now, that would make the instrument, the MOU, a very unique document. Indeed, if not one of a kind. It would provide for negotiation of the maritime boundary dispute, but only so long as no agreement was reached. There are, of course, such things as agreements to agree. This would be the opposite, an agreement not to agree. It is plainly no such thing. Kenya's new argument simply makes no sense. It is certainly not how Kenya understood the MOU during the negotiations that took place in 2014. The objective of those meetings was to reach an agreement on the maritime boundary. That is clear from the joint reports as well as the parties' internal reports. The exchange between Foreign Minister Baile and Foreign Minister Mohammed demonstrates this, as does the subsequent letter from Minister Bailey to Minister Mohammed. The ministers agreed at the end of the July meetings to meet again and attempt one final time to find an amicable solution. They did not say, quote, but unfortunately, we cannot achieve a solution because the MOU doesn't allow us to. Kenya's conduct, even after the present case was commenced, contradicts the new interpretation of the MOU. On 24 October 2014, 2 months after Somalia's application was filed, Kenya sent a note verbal to the UN Secretary General. It is at tab 20 and on your screens. In this document on page 2, Kenya states, quote, Kenya remains committed and continues to pursue more legitimate avenues to have the delimitation of the maritime boundary amicably resolved, most preferably through a bilateral agreement with the Somali Federal Republic, and in this regard wishes to inform that, notwithstanding the aforementioned actions by Somalis, that is the objection to Kenya's CLCS submission, bilateral diplomatic negotiations at the highest levels possible are ongoing with a view to resolving the matter expeditiously and with a view to continuing peaceful cooperation, security, and stability in the region. If another death blow to Kenya's new interpretation of the MOU is required, this note verbal deals it. It was sent at a time when Somalia's objection was still in effect, and after the CLCS determined that it could not even create a subcommission to review Kenya's claims. In other words, CLC action was not even possible. Yet, Kenya represented to the Secretary General that it would continue negotiations at the highest levels to achieve a resolution of the maritime boundary dispute expeditiously, not 10 or 20 years from now, not after the CLCS has acted, but expeditiously. Obviously, Kenya did not then consider the MOU a bar either to negotiations or to an expeditious agreement. Mr. President, members of the Court, I can state my conclusions very succinctly. The contemporaneous evidence, consisting of statements and conduct of the parties and of Norway as drafter and broker of the MOU, shows clearly and unambiguously that neither Kenya nor Somalia nor Norway ever considered the MOU to be a binding agreement on a specific means of settling the parties' maritime boundary dispute. To the contrary, all of the principals saw it for what it was, an attempt to remove potential obstacles to CLCS consideration of their outer continental shelf submissions by obligating them not to raise objections to each other's submissions and nothing else. Insofar as references were made to the maritime boundary dispute, these were understood to be for the purpose of separating that dispute from the claims submitted to the CLCS and of preserving and avoiding prejudice to the parties' respective positions on the boundary. The purpose of the penultimate paragraph of the MOU was not to settle the boundary dispute or prescribe a means for doing so, but to separate and insulate it from the effects of the parties' understanding on non-objection to their respective submissions to the CLCS. Mr. President, the interpretation given by the parties to the MOU, as reflected in their consistent conduct, does not support Kenya's attempt to use the MOU to block Somalia's recourse to the court in this case. And as Professor Pele has already shown you, neither does the MOU's text. Mr. President, members of the court, I thank you for your kind courtesy and patient attention, and I ask that you call Professor Sands to the podium.
Merci. Je donne la parole au professeur Philippe Sands.
Monsieur le Président, members of the Court, it's an honour for me to appear before you in these proceedings on behalf of the Federal Republic of Somalia. You've heard from Professor Pillay on the proper interpretation of the MOU, a slender document on which Somalia places much weight. And you've also heard from Mr. Reichler on the manner in which the MOU was negotiated and understood by the parties, a text and context that both indicate that the MOU is not and was never intended or understood to be an agreement concerned with the delimitation of the parties' maritime boundary. I shall address Kenya's claim that the MOU falls within the scope of the first reservation to its optional clause declaration. By that argument, Kenya hopes to persuade the court that it has no jurisdiction to examine Somalia's application under Article 36(2) of the statute of the court, and I'll seek to explain why Kenya's argument is without foundation in fact and in law. Before addressing that argument, however, an initial observation may be appropriate. In its written preliminary objections, Kenya invested considerable time and effort in seeking to persuade the court not to render the impartial and legally authoritative binding ruling that would bring to an end the protracted maritime boundary dispute that so disrupts relations between the parties. Kenya seems hostile to an authoritative judicial determination by this court, although not necessarily to an Annex 7 arbitration, depending on how one understands Professor Boyle. The apparent hostility towards this court was made rather clear again yesterday, and it's perhaps a reflection of Kenya's growing recognition that its claim to a maritime boundary based on a line of parallel is without merit, a claim that it has surely been advised would most likely fail before this court. Equally without merit is Kenya's unhappy reliance in its pleadings on the doctrine of unclean hands, an argument that might invite a wistful response. Is Kenya's particular invocation of good faith and mutual consent simply a means of prolonging its own unilateral conduct in the disputed maritime area? As Somalia has explained in its written statement, Kenya's reliance on its optional clause reservation, like its claim to a parallel maritime boundary, and we would say its clean hands argument, faces considerable legal and factual obstacles. Chapters 2 to 4 of our written statement contain a detailed exposition of the defects in Kenya's case. Anywhere but the ICJ in The Hague, Kenya in effect told you yesterday, and nowhere else either, unless subject to a delay of the kind that would entrench the status quo, continue the uncertainty, and prolong the instability. To accede to Kenya's request would extinguish the potential role of this court, the principal judicial organ of the United Nations, not only in this case, but in many others. Let's start with Kenya's optional clause declaration, made under Article 36(2), an integral part of the court's jurisdictional framework. Somalia and Kenya have been parties to the optional clause system for more than half a century, as both states made declarations under Article 36(2) shortly after they attained independence from colonial rule in the 1960s. Somalia on the 11th of April 1963, Kenya on the 19th of April 1965. Their long-standing participation in the optional clause system reflects a shared commitment to the object and purpose of the statute. That purpose, as the court observed in the Legrand case, is, I quote, to enable the court to fulfill the functions provided for therein, and in particular, the basic function of judicial settlement of international disputes by binding decisions in accordance with Article 59 of the statute." End of quote. This aim underpins Somalia's application. It is reflected too in the United Nations General Assembly's aspirations that, and I quote, "legal disputes should, as a general rule, be referred by the parties to the International Court of Justice." End of quote. As this court explained in the Nottebohm case, compulsory jurisdiction under 36(2), quote, "results from a previous agreement which makes it possible to seize the court of a dispute without a special agreement." End of quote. That previous agreement arises from the existence of convergent optional clause declarations by the states concerned. And in this case, contrary to what we heard yesterday from counsel for Kenya, the declarations of Somalia and Kenya are convergent, and they do allow the court to exercise jurisdiction. As the court explained in the Nicaragua case, optional clause declarations, I quote, "establish a series of bilateral engagements with other states accepting the same obligation of compulsory jurisdiction." End of quote. At its heart, therefore, the optional clause system involves a series of binding mutual obligations grounded in reciprocity. Those bilateral relationships reflect a shared recognition of this court's unique and significant role in the peaceful resolution of disputes between states. The bilateral character of the obligations established under Article 36(2) is significant because it indicates that only a deliberate, clear, and unambiguous exclusion of the court's jurisdiction can operate to oust the right of one state to bring an application before the court against the other. In the present case, it is readily apparent that no such exclusion applies. Let's look at the first reservation to Kenya's optional clause declaration. It covers disputes in regard to which the parties to the dispute have agreed or shall agree to have recourse to some other method or methods of settlement. As the parties have explained in their written submissions, no fewer than 34 other states have entered materially identical reservations in their optional clause declarations. To accede to Kenya's interpretation would therefore be to undermine the potential role of this court in respect of these declarations, a role for the court that is more important today than ever before. It would also be a novel and unprecedented step in the court's jurisprudence. As the then president of the court observed in a speech in 2010, and I quote, 40 states have limited their optional clause declarations by stipulating that any other mechanisms of dispute settlement, as agreed between the parties, will prevail over the general jurisdiction of the court. In the few cases where this condition has been at issue, the court found that it did not exclude recourse to ICJ adjudication. It's very difficult to see how this case could be any different, how the MOU could reasonably be interpreted as an agreement to have recourse to another method of settlement, or indeed to exclude the right of recourse to this court. Kenya's entire argument rests on the interpretation of a single sentence, an aspirational line that it says excludes judicial settlement of the dispute concerning the maritime boundary. That single sentence is located in a document that is, on its face, concerned exclusively with the delineation of the outer limit of the continental shelf. Without textual or contextual support, Kenya seeks to elevate that line into a binding agreement that requires the entire disputed maritime boundary, including the territorial sea, the EEZ, and the inner continental shelf, of which the MOU makes no mention at all, to be delimited only by negotiation between the two states. On Kenya's approach, that one line excludes any recourse to this court on any matter of maritime delimitation. And as Professor Pillay has explained, the single sentence mirrors the language of Articles 74 and 83(1) of UNCLOS. This is boilerplate language. It goes no further than the general provisions of international law that have bound the parties since they ratified UNCLOS. The line does not develop, supplement, modify, or magnify those general obligations. It says nothing about the right of recourse to the court, about the optional clause, or about other possible methods of judicial or arbitral determination. It contains no exclusionary language, not expressly and not impliedly, and it offers no details about the form, duration, and scope of any supposedly mandatory negotiations. It simply cannot bear the great weight that Kenya seeks to place upon it. In assessing Kenya's far-fetched claim, we would invite you to bear in mind a number of points. First, Kenya's optional clause declaration does not contain any express exclusion in respect of maritime delimitation disputes in general, or the maritime boundary dispute with Somalia in particular. Had Kenya wished to exclude such disputes from the scope of its optional clause declaration under Article 36, paragraph 2, it could very easily have done so at any time during the 5 decades since it made its declaration in 1965, as many other states have done. Indeed, Kenya's declaration expressly reserves the right at any time to add to, amend, or withdraw any of the foregoing reservations. It did not do so. Not before 2009, not in 2009, and not in 2014. Second, if the MOU had been intended to exclude judicial delimitation of the contested maritime boundary and to enshrine negotiations as the exclusive method of resolving the dispute, then one would expect the document to contain express and unambiguous language to this effect, given the far-reaching consequences such an interpretation would entail for both parties. It did not do so. There is no hint in the language of the MOU that the document was intended to exclude or prescribe any particular method of resolving the boundary dispute. On the contrary, the title and the text of the MOU make it clear that the document was concerned solely with the delineation of the outer continental shelf. The MOU was not intended to and does not concern matters of delimitation or dispute resolution relating to delimitation. Third, as Mr. Reichler pointed out, there is no evidence in the drafting history leading up to the signing of the MOU that either party believed itself to be agreeing to exclude recourse to judicial determination of the disputed maritime boundary. Kenya has offered no contemporaneous evidence, nothing, to suggest that the parties considered that they were renouncing recourse to the court or any other tribunal in favour of perpetual negotiations. Fourth, Kenya's attempt to characterise the MOU as an instrument that established a mandatory process for delimiting the parties' maritime boundary is undermined, fatally we say, by the fact that the document contained no reference to the maritime boundary within 200 miles. It did not contain any reference to the EEZ or the territorial sea, not expressly, not implicitly. Had the MOU also been intended to exclude the court's jurisdiction to determine the boundaries of the territorial sea and the EEZ, and had it intended to make bilateral negotiations the only possible means of delimiting those boundaries, then the text of the document, we say, would surely have referred to these zones expressly. Yet it says nothing at all about them. Indeed, the MOU itself defines the maritime area in dispute strictly in terms of the continental shelf. And as Professor Pele explained with great clarity, this is consistent with the singular purpose of the MOU, a document concerned only with the delineation procedures for the outer continental shelf. Fifth, the court will have noted that during protracted negotiations with Somalia in 2014, on no occasion did Kenya ever assert that the MOU fell within the scope of the first reservation to its optional clause declaration. Had it considered this to be the case, surely Kenya would have made that assertion. It did not do so. Sixth, and in relation to this last point, there is no evidence to indicate that before it filed its preliminary objections on the 7th of October 2015, that Kenya ever expressed the view, internally or externally, that the MOU was an agreement to settle the maritime boundary dispute by negotiation only, to the exclusion of all other means of peaceful settlement of disputes. It was only after Somalia seized the court that Kenya sought to characterize the document in this new and different light. Kenya's radical new characterization of the MOU is an invention of the fertile legal minds whose task was to create an exception after they were retained to assist in this case. Seventh, if, quod non, Kenya is right that the language of the MOU is an agreement to have recourse to some other method or methods of settlement, then it would appear to follow that the materially identical language of Articles 74 and 83 of UNCLOS would have the same effect. And this would have truly radical consequences that were surely not anticipated by the drafters of or the parties to UNCLOS. On Kenya's approach, Articles 74 and 83 have the effect of automatically depriving the court of jurisdiction under Article 36, paragraph 2 of the statute, in respect of any delimitation dispute concerning the EEZ or continental shelf of a state that is a party to UNCLOS and whose optional clause declaration contains a similarly worded reservation to Kenya's reservation. That would be a truly startling outcome, to put it mildly. Given that at least 33 other states that are parties to UNCLOS and the optional clause have entered the same or a similar reservation as Kenya, the consequence of this court acceding to Kenya's approach would seem to be to deprive the court of its optional clause jurisdiction over maritime delimitation disputes involving almost half of the 72 states that have accepted jurisdiction under Article 36, paragraph 2. Mr. President, members of the court, that is the conclusion that Kenya is inviting you to impose upon yourself. It cannot be right that so many states would have unwittingly deprived the court of its jurisdiction in this way. In short, our submission is that the MOU does not trigger Kenya's reservation to its optional clause declaration. Kenya's arguments to the contrary are unsustainable, as it surely knows, and it would have dire implications for the future role of the court, not least, but not only, in relation to the settlement of maritime boundary disputes. However, even assuming arguendo that the MOU was a binding agreement that was capable of falling within the scope of Kenya's optional clause reservation, this would not deprive the court of jurisdiction to hear Somalia's application. The reason for this is simple. If the MOU created any obligation regarding a negotiated settlement of the disputed maritime boundary, it was at most a limited obligation of endeavour, not of end. The MOU was not a pactum de contrahendo, an agreement to agree. It was at most a pactum de negociando, an agreement to attempt to agree. And as Mr. Reichler has explained, this is exactly what the parties did over a period of several months in 2014, but to no avail. After high-level, forceful, but ultimately futile negotiations between the parties reached an intractable deadlock. The parties themselves recognized this, and in a last-ditch effort to reach an amicable solution, did, as you have heard, agree to have one final meeting, but it never took place because Kenya, without notice, simply failed to show up and refused thereafter, as you have heard, to respond to Somalia's request for an explanation. Accordingly, having exhausted any obligation to negotiate under the MOU, the document could not trigger Kenya's reservation. In the Mavra Matters Palestine concessions case, the Permanent Court of International Justice observed, negotiations do not, of necessity, always presuppose a more or less lengthy series of notes and dispatches. It may suffice that a discussion should have been commenced, and this discussion may have been very short. This will be the case if a deadlock is reached, or if finally a point is reached at which one of the parties definitively declares himself unable or refuses to give way, and there can therefore be no doubt the dispute cannot be settled by diplomatic negotiation. And as the court explained in Nicaragua versus Honduras, I quote, "It is sufficient if, at the date on which a new procedure is commenced, the initial procedure has come to a standstill in such circumstances that there appears to be no prospect of its being continued or resumed." End of quote. While the context in that case was different, those words are an apt description of the situation in the present case. This court has defined negotiation as being, I quote, "a genuine attempt by one of the disputing parties to engage in discussions with the other disputing party with a view to resolving the dispute." End of quote. It's very hard to see how it can be said that negotiations did not take place, even if Kenya now seeks to attach rather different labels to what happened. The reality, too, is that both sides knew they were involved in negotiations, and they knew they were going nowhere and would lead nowhere, not in a real sense, with no prospect of moving beyond the standstill. To recap, negotiations between the parties began in March 2014. The first round took place in Nairobi. The title of the agenda referred to the Kenya-Somalia maritime boundary meeting. At that meeting, the parties' delegations articulated their respective positions concerning delimitation of the maritime boundary. The Kenyan delegation presented a detailed multi-slide PowerPoint presentation setting out Kenya's argument in support of its claim to a boundary along a parallel of latitude. Amongst other things, the two negotiating teams discussed the reasons for Kenya's departure in 2005, a decade earlier, from its previous recognition of an equidistance boundary. They discussed the starting point for the determination of the maritime boundary, the location of the baseline and base points, and the path of the possible maritime boundary line. Despite those detailed exchanges, the joint report recorded that the delegations could not reach a consensus on the potential maritime boundary line acceptable to both countries to be adopted. Following consultations with their respective principals, a further round of high-level negotiations took place in Nairobi in July 2014. This was at a very senior level. The foreign ministers of Kenya and Somalia attended those talks. In Kenya's words, they took place at the highest levels possible. Yet Kenya maintained its insistence that the boundary line must follow a parallel of latitude. Somalia continued to emphasize that in accordance with UNCLOS and established principles of general international law, an equidistance approach was the appropriate methodology for the delimitation. Despite intense discussions, the parties did not make any progress at all, and they came no closer to reaching an agreed settlement of any part of the boundary or even a common view as to the appropriate method of delimitation. The state of deadlock was reflected in a comment by the Somali foreign minister, who asked in frustration at the end of the talks, and I quote, "How long would both countries continue to have their delegations entangled in these heated discussions without any possible solution?" Just offer an aside. Our friends from Kenya remarked on the curiosity of our distinguished agent drafting that report on the July negotiations in English rather than in Somali. Annex 24 to Somalia's memorial is another report in English submitted by the same agent on the 1st of April 2014. And that illustrates that English is in fact the distinguished agent's working language, as she has lived and worked abroad for many years, and that she frequently submitted her reports in English. Notwithstanding the deadlock, a third round of negotiations was scheduled to take place in Mogadishu, as you now know, a final opportunity to explore possible common ground. Contrary to what you heard yesterday, those negotiations were not seen merely as one of many potentially future rounds of negotiations, but were described by both parties as an attempt, one final time, to reach a negotiated solution. As the court has seen in our written pleadings, however, the Kenyan delegation chose not to show up. No explanation or advance notification was provided. They just didn't arrive, and they never gave any prior notice or any reason. The first two rounds of talks having failed to make any progress, and the third having been thwarted by a Kenyan no-show, it was clear to Somalia that an impasse had been reached. The position at the date of Somalia's application to the court is therefore reminiscent of the situation that pertained in the rights of passage case, where the court observed that, and I quote, while the diplomatic exchanges which took place between the two governments disclosed the existence of a dispute between them on the principal legal issue which is now before the court, an examination of the correspondence shows that the negotiations had reached a deadlock. End of quote. If Kenya's approach is correct, then the parties will be obliged to engage in an indefinite process of negotiation, notwithstanding that previous attempts had ended in intractable deadlock. The parties must continue to negotiate, and only to negotiate, no matter how great the distance between them, between their respective positions, no matter what unilateral activities Kenya is undertaking in the disputed area, and no matter how entrenched or unreasonable Kenya's stance may be in the negotiations. They must continue to negotiate, Kenya says, even after one of the parties fails to attend a final meeting at which the negotiations are to conclude. Kenya's position, we say, is a recipe for deadlock, for a guarantee of indefinite conflict. Mr. President, it seems that Kenya is now aware of the weakness of its primary argument, and that is why it has chosen to advance another argument, both subsidiary and lackluster, which is said to be based on Part 15 of UNCLOS. That argument was limited to a single paragraph in its preliminary objections, one in which Kenya contended, without explanation or elaboration, that, and I quote, the UNCLOS Part 15 methods of settlement would also trigger Kenya's reservation and exclude the court's jurisdiction, end of quote. You heard Kenya's counsel yesterday. Professors Boyle and Lowe sought to add to that argument, or non-argument. They certainly made it longer, indeed so much longer that one is bound to wonder whether it reflects a recognition of an understanding of the weakness of their main argument. But that length did not make it any more plausible. And let me be blunt, the argument is hopeless. For Part 15 of UNCLOS does not and cannot affect the binding agreement established by Kenya and Somalia's matching, convergent, overlapping, optional clause declarations. If Kenya is right, the court's jurisdiction will be extinguished with respect to maritime disputes between the states that are parties to UNCLOS with a similar optional clause reservation to Kenya. The agreement that arises by virtue of the matching declarations made under Article 36, Paragraph 2 of the statute, and they are matching, and they do converge, and they do overlap, takes priority over the dispute resolution procedures contained in Articles 287 of UNCLOS. Article 282 of UNCLOS makes the relationship between these provisions clear, a point we emphasised in our written application and to which Kenya has offered no credible response in its written pleadings or yesterday. Article 282 provides as follows. If the states parties which are parties to a dispute concerning the interpretation or application of this convention have agreed through a general, regional or bilateral agreement or otherwise that such dispute shall, at the request of any party to the dispute, be submitted to a procedure that entails a binding decision, that procedure shall apply in lieu of the procedures provided for in this part, unless the parties to the dispute otherwise agree. Many leading commentators have repeatedly confirmed that Article 282 has the effect of ensuring that the jurisdiction established by convergent optional clause declarations takes precedence over the dispute settlement procedures contained in Part 15 of UNCLOS. For example, in his recent textbook on the international law of the sea, Professor Tanaka confirmed there appears to be little doubt that the optional clause under Article 36(2) of the statute of the ICJ is a procedure that entails a binding decision set out in Article 282. It would seem to follow that between two states which have accepted the optional clause, the jurisdiction of the ICJ prevails over procedures under Part 15 of UNCLOS by virtue of Article 282. Professor Treves too concurs with that analysis. As he put it, the acceptance by all parties to a dispute of the court's compulsory jurisdiction under Article 36, paragraph 2 of the court statute can be considered the agreement mentioned in Article 282. And he continues, the consensual aspect, which seems to be the fundamental requirement of Article 36, paragraph 2, undoubtedly exists, so that it is reasonable to conclude that the parties have agreed otherwise. Accordingly, Professor Treves states that whenever both parties to a dispute have accepted the optional clause, ICLOS should declare that it has no jurisdiction over the dispute as a consequence of the operation of Article 282. And Judge Pete C. Rao confirms this understanding of the relationship between Part 15 of UNCLOS and Article 36(2) of the statute of the court. He writes, the agreement referred to in Article 282 UN Convention on the Law of the Sea may be recorded otherwise, for example through separate declarations, such as declarations made under Article 36(2) ICJ statute. These authorities are fully consistent with the UNCLOS commentary which we cited in our written statement. The authoritative commentary quoted at paragraph 3.83 of our statement explains, Article 282 mentions that an agreement to submit a dispute to a specified procedure may be reached otherwise. This reference was meant to include, in particular, the acceptances of the jurisdiction by the International Court of Justice by declarations made under Article 36, paragraph 2 of the statute of that court. And this has also been the view of Professor Boyle, at least until yesterday. In his article dealing with Article 282, which was published in 1999, he wrote, thus, two states which have made declarations in similar terms under Article 36(2) of the ICJ statute will remain subject to the compulsory jurisdiction of the ICJ even in LOS convention cases. This view seems to have been abandoned yesterday. Professor Boyle began his new approach by accepting correctly that if two states entered identical optional clause declarations, then Article 282 would ensure that these optional clause declarations prevail over any alternative UNCLOS Part 15 procedure. Professor Boyle's hypothetical example rightly recognized that the parties to UNCLOS intended the court's jurisdiction under the optional clause to trump the other methods of dispute resolution set out in Part 15. Professor Boyle proceeded to attempt to distinguish the present case from a case where there are identical optional clause declarations. And that is where, with the greatest respect, we say he fell into error. He says that Kenya's reservation means there are no matching optional clause declarations between the parties, and therefore the conditions stated in Article 282 are not met. It is not clear to us whether in making this argument, Professor Boyle now suggests that jurisdiction will only exist where optional clause declarations are identically worded. If so, that is very obviously wrong, as this court has long ruled. To bring the case within Kenya's reservation, Kenya has to establish that by signing UNCLOS, the two parties agreed to submit their maritime boundary dispute to the settlement procedures contained in Part 15. However, while Part 15 of UNCLOS does establish dispute resolution procedures, as you know, it contains a specific exception in Article 282, where states have agreed that a dispute shall be submitted to some other procedure that entails a binding decision. As we've seen, the exception in Part 15 is widely accepted to include situations where both case states have entered optional clause declarations. Accordingly, in order to persuade you, this court, that you lack jurisdiction under the optional clause, Kenya is now forced to rely on a treaty, UNCLOS itself, that contains a deliberate renvoi back to the optional clause, and which deliberately defers to jurisdiction under the optional clause. Kenya now argues that UNCLOS engages its reservation while simultaneously relying on its reservation to exclude a provision of UNCLOS. One might call this a sort of theory of double renvoi. We might also call it double bootstraps, a sort of game of endless ping-pong back and forth between the two instruments. But the essential idea is that each instrument extinguishes the other. The argument certainly has a quality that is dizzying, but perhaps not in the way it was intended. In the present case, there can be no doubt that both conditions established by Article 282 of UNCLOS are met. The first condition, that the parties have agreed to submit their dispute to a procedure that entails a binding settlement, is met by virtue of the converging optional clause declarations of Kenya and Somalia. The second condition, that the body selected by the parties must have power to interpret and apply UNCLOS in order to resolve the dispute, is also undoubtedly satisfied. This court has jurisdiction to interpret and apply UNCLOS. Indeed, that is a function it has found no difficulty in fulfilling in many recent cases. Somalia and Kenya have both ratified UNCLOS and are therefore bound by its provisions vis-à-vis one another. Somalia's application expressly states that the law applicable to this dispute is the 1982 United Nations Convention on the Law of the Sea, and the application explicitly requests the court to determine the disputed maritime boundary by applying Articles 15, 74 and 83 of UNCLOS. So Somalia's application falls squarely within Article 282. Lastly, I turn to Kenya's unhappy attempt to invoke as an admissibility argument the doctrine of unclean hands against Somalia. In its preliminary objections, Kenya objected loudly to the steps that Somalia had previously taken in relation to Kenya's CLCS submission, and complained that Somalia had breached the MOU by seeking to resolve the issue of delimitation before the CLCS has delineated the outer continental shelf. Kenya claimed that this rendered Somalia's application inadmissible. Kenya advanced this argument half-heartedly in its written pleadings, just 4 terse paragraphs at the end of its written submission. Yesterday it received no more than an oblique passing reference, if it can be called even that, in the oral submissions. We understand why Kenya has gone light on this argument and said nothing about it yesterday. It is manifestly wrong. First, it's based on the same erroneous conflation of delimitation and delineation that permeates the entirety of Kenya's preliminary objections. Second, Somalia is not seeking to invoke the MOU as the basis for the court's jurisdiction. Even if Somalia were in the breach of the MOU, which it is not, this would not preclude Somalia from invoking its entirely separate rights under Article 36(2) of the statute. Third, there is no precedent for applying the unclean hands doctrine in proceedings between states. On every occasion when the court has been invited to apply the doctrine, it has declined to do so. As noted in the latest edition of Brownley's Principles of Public International Law, text, I would add, that admirably reflects the spirit and approach of the distinguished author of earlier editions, the International Court has never applied the doctrine, even in cases where it might have done so. And fourth, regardless of whether it could ever be applied in the context of an interstate case, the court's case law confirms that accusations of bad faith of the type levelled against Somalia cannot bar the admissibility of an application. In any event, Kenya's allegations are unfounded in fact. Somalia's objection to Kenya's CLCS submission was a reasonable measure in the circumstance. It was taken as a last resort in response to Kenya's persistent and unjustified assertion of a parallel boundary claim and its persistent and unjustified unilateral activities in the disputed area. These jeopardized and hampered the possibility of reaching a final agreement, contrary to Articles 74 and 83 of UNCLOS. Somalia acted reasonably in the face of Kenya's unilateral conduct. It came to this court. There is no more reasonable act one could imagine. As to Somalia's objection to the CLCS, it was withdrawn, and Kenya's submission is now before the CLCS without any real delay.